Some technical problems. Professor Shemtov is a full professor of intellectual property and technology law at the Queen Mary University of London, and he is also the director of the Queen Mary Intellectual Property Research Institute. He will speak about the patentability of the AI-generated inventions. Please, Professor Shemtov.
Thank you. Thank you, Emanuela, for the kind invitation. I want to thank everyone also in the audience for staying all the way until what is commonly referred to as the graveyard session, which is the last one. So bear with us. Let me start. Some of those slides would be a little bit more detailed than my discussion, and this is for the benefit of the people who are perhaps less fluent in patent law, or at least the aspect of patent law that I intend to discuss. So again, no point, I guess, spending much time on that. AI-assisted inventions. What do we mean? We mean, or when we refer to AI-assisted invention, we are referring to innovation where AI plays a significant role, but not an exclusive role in the invention making process, or tools that help analyzing data, identifying patterns, generating solutions, and so on and so forth, but the human still plays the role. By the way, it's a matter of state of the art, simply. It is the case across the board. We did not reach a point yet where AI simply does everything. So a human plays the role, but the question is what role, and whether this role is sufficient for us to be able to identify a human inventor in that process. Now, why exactly, if I'm putting this, why exactly is that important? So why exactly is that important? So the next slide. Thank you. So I'm going to. This is just a list of the core issues that are relevant for discussion in relation to AI-assisted inventions within the realms of patent law. I'm going to focus on the first one, but of course issues like inventive step, who is the person skilled in the art, obviousness, general common knowledge, sufficiency, and even infringement. All of those are worthy topics that perhaps we could cover at a different time. Let me now move to the requirement for designating an inventor. So when we apply for a patent, one of the things that we need to indicate on our patent application is who is the inventor. Not who is the applicant, who is the inventor. The applicant, of course, appears there. So, for example, there can be an application under the name of IBM. So IBM would be the applicant, but they would designate Emanuela as the inventor because Emanuela was responsible for the R&D team that worked on that particular invention. So the applicant is one thing, and the identity of the inventor is another thing altogether. And here you have a list of the actual provisions in various jurisdictions where this requirement is listed. Now, all of this is fine, but what exactly do we mean by an inventor? Who can be an inventor? Now, I'm not going to go with you through, this is probably good for the history books, the whole, what I call the Davos saga. It has ended definitely for most intents and purposes. But what I would refer to it because it provides, or it sets the scene for our discussion. So before the Davos litigation, I was asked by the European Commission to prepare a study on the concept of inventorship under patent law And one of the things that they did there was, so this was about 6 or 7 months before the first Davos was filed, the patent application, not the one that Christoph was referring to, not the copyright one. So one of the things that I've done was to look at what do we mean by inventorship under different domestic laws. And I looked at a variety of jurisdictions that were selected on a number, on the basis of various criteria. But what I found is that, can we go please to the previous one? Yeah, that an inventor is a person, so of course a natural person that plays an intellectual part in the conception of the invention. Doesn't play any part, an intellectual part. So it's not enough, for example, to buy equipment, to own equipment, to provide finance. Intellectual part in the invention making process. The American standard at that point was actually intellectual domination. So when I looked at the law in the United States, that can be traced back, or could be traced back to a 1965 decision, a person who maintains intellectual domination over the process. Little did I know that a few months afterwards there would be a decision of the Court of Appeal for the Federal Circuit where the intellectual domination test would not be applied or not rejected. A case that has nothing to do with AI has to do with a harness for a dog, right, to which you connect the lead. I'll come back to it in a minute and explain how and why it is relevant. If we can move to the next slide. Another thing that this study opined on is that AI cannot be designated as an inventor. Now we all know now that post-Davos that is indeed the case, so AI could not be designated as an inventor on a patent application, but that still leaves the question of when and under which circumstances can we designate a human actor. In other words, what does the human need to do in order to be considered as an inventor? And this is the core, the heart of whatever remains of my presentation here, and I will. Okay, we can move through that, so that's fine. Outcome refused, so we know that that was refused across the board, and then these are the two approaches that I would like to focus on. February 2024, a decision, not a decision, a set of guidelines or guidance that was published by the USPTO, Patent and Trademark Office, and very recently a decision by the German Federal Court, the last one, if you would like, on Davos, so the very end of the Davos saga. And it's relevant not only that it tells us that an AI cannot be designated as an inventor, but it also provides helpful and in my view very sensible guidance as to what do we need to look for in a human in order for such a human to be considered an inventor. And I will compare and contrast the two approaches and leave you to think about which one you think make more sense. I'll explain why I think that the German approach is much more sensible. Of course, in relation to the United States, we need to remember that it is the USPTO. This is not a judicial decision. We may actually have, it is not binding on the courts, and you may have a decision, and there may be an appeal when a court, the Court of Appeal, for example, for the Federal Circuit would say, well, we actually don't think that it makes a lot of sense. But let's continue, please. So what did the USPTO actually say? So the USPTO went back to a case that has to do with joint inventorship, where a number of factors were listed, known as the PANU factors, right? It comes from PANU versus Law Lab. And the court stated that in order to be considered as an inventor, a person has to make a significant contribution to each of the claims. Fine. What do we mean by significant contribution? The court listed three principles. You need to contribute in some significant manner to the conception or reduction. This contribution must not be insignificant in quality when it's measured against the whole invention, and you need to do more than merely explain to the real inventor what is it that you are seeking. So if you're kind of ahead of a project, you coming to your team and say, look, that's what I want you to do in broad terms, and then you leave the room, that's not enough. Fine. Up to now, nothing really controversial. But if you can move to the next slide, please. But it is the USPTO guiding principles in applying the PANU factors to an AI-assisted invention-making process where things become, in my view, somewhat more problematic. So let's have a look at those principles. A natural person use of AI system in creating does not mean that person that the natural person is not an inventor. Fine. Second, merely recognizing a problem and having a general goal or a research plan to pursue does not rise to the level of conception. Again, up to now, not a problem. Can we just have another press? Factor 2, or principle 2, also not problematic. It is in principle 3 where I think, and I'll explain why, that the USPTO got it somewhat wrong. The USPTO explains reducing an invention to practice alone will not be a significant contribution. It goes on to explain that a natural person who merely recognizes and appreciates the output of an AI system as an invention, particularly when the properties and utility of that output are apparent, is not necessarily an inventor. Now, I'll explain to you in a couple of minutes why I think that this, first of all, deviates from the general spirit of patent law and why it makes little sense. Next slide, please. And another press, please. No. The USPTO explicitly states here, maintaining intellectual domination is not, on its own, sufficient. Simply owning or overseeing an AI system in the creation of the invention without providing significant contribution. Remember, significant contribution has been construed as contribution which is not apparent. Now, I would like you to think about those of us who are speak the patent law language, replace apparent, because that's very clearly what the PTO has in mind. Replace apparent with obvious. Something not apparent meaning something which is not obvious to the skilled person. Now, the implications of these guidelines. First of all, I was lucky enough to be in Washington in an expert roundtable about 3 weeks ago, and I had a chat in confidence with one of the former directors of the USPTO, and I was it was comforting, at least, to hear that by and large shared my views in relation to the downsides in this decision. He actually thinks that when it gets to court, there's a good chance that would be looked at again. But again, who knows? Now, what are the results, or what is the outcome of the USPTO guidelines as we stand? Think about the following, where we have worthy innovation with societal benefits. We have a natural person that maintains intellectual domination over the process, but the AI generates an output, and the person that oversees the process recognizes and appreciates the significance and utility of the output, but the USPTO or any objective bystanders would find that any other skilled person in that person's shoes would have also recognized and appreciate the significance and utility of that output. According to the USPTO, you should not have a patent under such circumstances. Now, as a matter of plain law, I have an issue with these guidelines because what they do, first and foremost, they conflate the requirement for inventive step or obviousness with the requirement of inventorship. Why should it be important or crucial at that point to hold that that's the case? Now, let me give you the following scenario. Let's say that I have an AI system. Let's say that the AI system generates an output. Let's say that when it generates the output, I recognize the significance and utility of this output in order to address a certain technical problem, right? And that leads to an invention. Now, there can be two scenarios. This AI tool that I used is part of the state of the art or is not part of the state of the art. If it's part of the state of the art, there's not going to be any patent in any event, because this type of innovation is going to be thrown out at the obviousness or inventive step level of inquiry. If it's not part of the state of the art, what is the justification not to grant a patent here? I would like, and society would like or would have an interest to encourage such innovation. Remember, when the AI tool is not part of the state of the art, this type of innovation is not necessarily likely to be replicated by a competitor. So you cannot say, well, I'm not giving you a patent because someone else is likely to come up with this invention, and therefore there's no point rewarding and incentivizing this type of innovative process. The AI tool has been, let's say, developed in-house, and therefore is not part of the state of the art. So when I look at the public policy considerations that underpin patent law, and I'm summarizing something a little bit more detailed here. As I said, there are two options. When the AI tool is part of the state of the art, then there's not going to be any invention, and rightly so, that should be the case. When it is not part of the state of the art, I am not able to identify a solid justification why such innovation could not or should not be rewarded with a patent. In the end of the day, if you think about it, if I'm an inventor, if I stumbled upon, and actually that's what I wrote at the time in my study, if I stumble upon the inventive concept by sheer dumb luck, I'm still, not due to an inventive effort, I'm still entitled to a patent. So you do not say, well, anyone in your case, if they would set and clicked on the computer, they would have come across the inventive concept under such circumstances. They would also, it would be obvious to them how to apply it, and therefore you should not be recognized as an inventor. We don't do this, or we don't go through this exercise, and therefore I think it is misjudged on the part of the US, or misjudgment on the part of the USPTO. Critique, I went to the, I explained, I think, in a nutshell, why when the AI tool is part of the state of the art, no patent, but when the AI tool is not part of the state of the art, there is a clear public policy justification to award a patent. We've always done that. And I would like, just with your permission, very, very quickly, to move to Germany, where we'll spend very, very short time, because I think that is actually and refreshingly, a very sensible approach. According to the decision, this decision, which is 4 months old, the federal court said clearly, who is the inventor? The natural person, so again, Dabus out, who significantly influenced the AI system. And when you see what the German court means by significantly influence, I put it to you that what they're basically saying is intellectual domination. They just don't use the previous American terminology. A human contribution must play a significant role. The court goes on to explain that there is always going to be a human which significantly influences the AI system because, and there's a quote, there is no such thing as a system that searches for technical teaching without any human preparation or influence. So as long as someone is there, not merely providing a system, but overseeing the system, steering the system, instructing the system, irrespective of whether this instruction is obvious or not, you're going to have your human inventor. Effectively, what that means is that under the German approach, we are not going to find ourselves with a worthy innovation that stays outside the remit of patent law, and therefore it would be continued, or it will be continued to be incentivized. Under the American approach, as it sits now, and I call the USPTO the American approach, you may end up with worthy innovation, which is unpatentable because you are not able to identify a human inventor. And I think I kept to my time here. So with this, I will, yeah, is it the next one? Click. Thank you. I will conclude. Thank you very much.